The intensification of geopolitical tensions and the growing prioritization of national interests are reshaping the dispute resolution landscape. As political and economic fragmentation increases, cross-border disputes are becoming more frequent, but how they are resolved is also evolving. Arbitration and mediation have long been the preferred mechanisms for handling international disputes, valued for their neutrality, flexibility, and enforceability. However, in a world where governments are increasingly assertive in protecting sovereignty and strategic economic policies, businesses and state actors may be reconsidering their options. One significant factor driving this shift is the stronger role of state interests in public policy. National governments may seek to resolve disputes within their own legal systems to maintain control over politically sensitive industries, including those related to national security, technology, and natural resources. This could lead to greater reliance on domestic courts rather than arbitration or mediation, particularly in cases where public policy considerations are a central issue. Another challenge is declining trust in neutral dispute resolution forums. As geopolitical rivalries intensify, concerns over the impartiality of arbitration tribunals and mediation bodies are growing. If parties believe that arbitrator selection, procedural rules, or enforcement decisions are being influenced by geopolitical biases, they may prefer the familiarity and perceived fairness of their own national judicial systems. Enforcement is also becoming a concern. The effectiveness of arbitration has traditionally been reinforced by the New York Convention, ensuring that arbitral awards are recognized and enforceable across jurisdictions. However, increased state intervention and protectionist policies could make enforcement more difficult, particularly in cases involving public interest arguments. While mediation is less reliant on formal enforcement mechanisms, it could also be undermined if parties lack confidence in the enforceability of negotiated settlements. Rather than signaling the decline of arbitration and mediation, these pressures may instead drive adaptation. Hybrid dispute resolution models could emerge, integrating ADR principles while addressing national interests and public policy concerns. Institutions may need to focus on reinforcing transparency, emphasizing party autonomy, and improving procedural efficiency to maintain their relevance. Whichever happens, the fact remains that geopolitical tensions will fuel disputes, and there's no disputing that.